Greetings to you, students. I want to congratulate you for having gone so far with your studies. Welcome to our second semester of Criminal Procedure B. I am Advocate Sokoni. I will be taking you on this module, I think, to as far as August, if I'm not mistaken. But I will be giving you an assessment. I think I'd rather give you an assessment which is an assignment, right? Because for this module, again, you will have two assessments for your DP. What is important, guys, here is that we need to recap on what we did the last semester, on the first semester, which was trial procedure and the bail and indictments and also the charge sheet. So we'll also be dealing with that. But what is important now, let us first deal with the Child Justice Act. Everybody must read the Child Justice Act, right? Now, what is important here is that everybody must make sure that you are registered for this module, right? And also this module will be 2 LCP 302 or LCCP 302 for those guys who are still using the old code. So we've got a new code and an old code, right? Okay, let us deal with the Child Justice Act. The most important sections for our purposes for now in the Child Justice Act will be sections 15 and section 25, right? But you must also read section 21 when dealing with the release of a child offender before the first appearance in court, because this applies as well to both adults and children, that they are released before their first appearance in court. Now, if you read those sections, they will tell you exactly what is the procedure. Okay, first of all, the Child Justice Act is Act 75 of 2008. You've got to have that act if possible. I will try and send it to your class rep so that you can have a copy. It is important to have these acts, especially the Child Justice Act and the Criminal Procedure Act. The other day I was in court and the prosecutor said we are going to make an application in terms of section 68. Imagine when you go to court and you do not have a copy of this in your phone, because I tell you, people said it is unethical for anybody to use a phone in court. I am telling you, there's nothing wrong with using a phone in court as long as the phone is not going to make a noise. You won't be making those beep noise when you are getting your messages, and then your phone will be ringing in court. That is contempt of court. You cannot do it. But I advise everyone that when you go to court, even in my class, but in class it's okay because we have Wi-Fi, and when you go to court you must have data, so that when the prosecutor stands up and says we are going to make an application in terms of section 68, you will know exactly what is that, even if you don't have to know everything in the criminal procedure. Otherwise you will go mad if you are going to know the provisions of each section. But you are allowed to consult your phone and see as to what is meant by section 68. I guess that everyone now knows what is an application is in terms of section 68. All right, so let us continue. We will be dealing with section 80 up to section 87 of the Criminal Procedure Act. But we must also deal with section 155 and 156. Those sections are very important for our purposes. Everybody has to know this and make sure that you know exactly what to do. Students, for the purposes of our class, the most important thing that you should know, you must be able to apply the basic principles of criminal procedure. Remember, in the first semester, we talked of the requirement for search and seizure, what sections are important. So those are the basic principles. What does the law says? What does the criminal procedure says? What is the procedure when somebody has to search and seize property suspected to have been involved in a commission of a crime? So that is very important. Those are the basic principles. Basic principles, things like we talked of section 60, subsection 4 to 9 of the criminal procedure, where we were talking about releasing a person on bail in the interest of justice. And I told you that in the interest of justice goes two ways. It could be the prosecutor proving to the court that in the interest of justice, the particular applicant or accused cannot be allowed to be admitted in bail because the interest of justice doesn't allow. This person has got pending cases. This person has not disclosed his previous convictions. This person has been interfering with witnesses and also interfering with the investigating officer. So such person, in the interest of justice, cannot be allowed to be admitted in bail. But the opposite, if that person hasn't done all of those, then the interest of justice allows that person to be released on bail. So those are the basic principles that you need to understand. Okay, now let's talk about the indictment. What do we mean by an indictment? Right? Okay, first of all, let us deal with a charge sheet, right? A charge sheet, when a person, before a person is brought to court and the prosecutor has got the docket. The docket is that file that is prepared by an investigating officer where all the information, all the evidence is contained, and that docket is brought to court for the court to make a decision or prefer charges, what we call prefer charges. Remember, I told you that in court, when a person is arraigned before court, the person is brought before a magistrate, the prosecutor will prefer charges. How does a prosecutor prefer charges? He will say, for instance, Mr. Mbuli, you are guilty of an offense of murder in that on the 3rd of March at Mpumloana's tavern, you did and unlawfully, intentionally and unlawfully killed a human being by the name of Senzo Zibula. That is now preferring charges. What is important when preferring charges is that all the elements of the crime should be present. We know what is the definition for murder. Murder is an intentional, unlawful, and intentional killing of a person, right? And what is rape? Rape is an unlawful and intentional having an intercourse with a woman against her will or without consent. So the elements there will be, there must be consent, and the other element will also be have the penetration. If there was no penetration, then that means there is something wrong with that charge. That charge will be defective, because for a charge to stand the test of time, all the elements should be present. Okay, we've gone 10 minutes now. Let me take another break, and then we will continue again.